Restitution. Restitution meaning. The expression restitution has not been defined in the code, but it is an act of restoring a thing to its proper owner, as defined in Concise Oxford Dictionary. Restitution means the restoring of anything unjustly taken from another. It provides for putting a party in a possession of land, tenement, or property who had been unlawfully dispossessed, deprived, or dispossessed of it. In other words, restitution means restoring to a party the benefit which the other party has received under a decree subsequently held to be wrong. The word restitution in its etymological sense means restoring to a party on the modification, variation, or reversal of a decree or what had been lost to him in execution of the decree or in direct consequence of the decree. Doctrine explained. The principle of the doctrine of restitution is that on the reversal of a decree, the law imposes an obligation on the party to the suit who received an unjust benefit of the erroneous decree to make restitution to the other party for what he has lost. The obligation arises automatically on the reversal or modification of the decree and necessarily carries with it the right to restitution of all that has been done under the erroneous decree, and the court in making the restitution is bound to restore the parties so far as they can be restored to the same position they were at the time when the court began its erroneous action of disposing had placed them before. Section 144 does not confer any new substantive right, it merely regulates the power of the court on their behalf. It is the bounden duty of the court to see that if a person is harmed by a mistake of the court, he should be restored to the position he would have occupied but for the mistake. Similarly, on the reversal of a judgment, the law places an obligation on the party who received the benefit of the erroneous judgment to make restitution to the other party for what he has lost, and it is the duty of the court to enforce obligation unless it is shown that the restitution would clearly contrary to the real justice of the law. In Halsbury Laws of England, it is stated, any civilized system of law is bound to provide remedies for cases of what has been called upon unjust enrichment or unjust benefit, that is, to prevent a man from retaining the money of or some benefit derived from another which it is against the conscience that he should keep. The jurisdiction to make restitution is inherent in every court and can be exercised whenever justice of the case demands. Illustrations. A obtains a decree against B for possession of immovable property, and in execution of the decree obtains possession thereof. The decree is subsequently reversed in appeal. B is entitled under this section to restitution of the property even though there is no direction for restitution in the decree. In the appel, to A obtains a decree against B for 5,000, recovers the amount in execution, decree is subsequently reversed in appeal. B is entitled under this section to get his 500 back for the refund of the amount together with interest up to the date of prepayment, though the appellate decree may be silent as to interest. Object. The doctrine of restitution is based upon a well-known maxim, actus curiae neminem gravabit, act of the court shall harm no one. In the words of Lord Keynes, one of the first and highest duties of all courts is to take care that the act of the court does no injury to the suitors. The law also imposes an obligation on the party who receives benefit of an erroneous judgment to make restitution to the other party for what he has lost. It is the duty of the court to enforce the obligation. In other words, a wrong order should not be perpetuated by keeping it alive and respecting it. Thus, doctrine of restitution is based upon equitable principles. In proceeding for restitution, the court should pass an order consistent with the justice to both the parties. The jurisdiction to grant restitution is not confined to the cases where covered by 144 section. It extends to all cases which do not come strictly within the section. In other words, to grant restitution is not confined to the cases covered by 144 section. Extend to all cases do not come strictly. The court has inherent power to order restitution whenever justice demands. In Jai Barham versus Kedarnath, Privy Council said it is the duty of the court under 144 CPC to place the parties in the position which they would have occupied but for the decree or such part thereof has been varied or reversed. Nor indeed does this duty or jurisdiction arise merely under such section. It is inherent under the general jurisdiction to act rightly and fairly according to circumstances towards all parties. Illustration. A obtains a decree against B and recovers the amount due under the decree by execution. Subsequently, it is found B was dead at the time of institution of the suit. Decree is a nullity. And the court, having alleged execution while there was legally no decree at all, has inherent power to rectify the mistake and order restitution. Nature and scope. Section 1. Whatever the code embodies the doctrine of restitution does not confer any new substantive right to the party not available to the general law. Section merely regulates the power of the court that behalf. It is a paramount duty of all courts to ensure that they do no injury to any applicant. Merely regulates the power of the court on behalf of the payment. Before restitution can be ordered under the section, the following case may be Alexander Roger versus Comptoir de Paris.